First of all, I want to thank all of you for being here today for jury service. I know you're all busy. I know that you all have very many important things to do. I know it's very uncertain times, but I really want to let you all know that I do appreciate you all being here this morning. And what we're going to be doing today is very important. Throughout the history of our country, trial by jury has been a vital constitutional right. And I know that if you were in trial, you would want jurors such as yourselves. And by your attendance and participation, you're going to perform an important civic duty. And again, I appreciate you being here, and I know that everyone here does as well. If you're wondering why I'm not wearing a mask, it's because I have a lot of talking that I need to do today, and so I think I need to be clear as I'm going through this. I also want to let you know that I've been fully vaccinated. I feel like I'm talking about one of my golden retrievers when I say that. But on the other hand, I'm really glad you're here today, and so this is what we're going to do. We're going to be hearing a criminal case today, and it is called the State of Washington versus Antonio Waldo. And the state has charged the defendant with the crime of criminal trespass in the second degree. The defendant has entered a plea of not guilty to this charge, and he is presumed innocent throughout the trial today until you go into deliberation. The filing of the charge itself is not evidence that, in fact, he did anything wrong. The state of Washington is represented by the Deputy Prosecuting Attorney, Toby Crowell. And Mr. Crowell, would you please introduce yourself?
Good morning. My name is Toby Crowell, and I work for the prosecutor's office. I'm a deputy prosecutor.
And then did you want to introduce your co-counsel?
Yes, and also deputy prosecutor with me trying the case today will be Megan Dunlop.
Hello, everyone.
Thank you. And then the defendant is represented by Joseph Kaczmarek. Mr. Kaczmarek, could you introduce yourself, please?
Good morning, everyone. My name is Joe Kaczmarek. I work with the Cowlitz County Office of Public Defense, and I'll be representing Mr. Waldo today.
Okay, and did you want to introduce Mr. Waldo?
Mr. Waldo?
And then co-counsel when you're ready.
I'm sorry.
Go ahead.
My name is Antonio Waldo. I'm the defendant today.
Okay.
And
Probably the first rule is turn off your phones.
I'll be assisted today by Charles Angelico, who's another defense attorney in the Office of Public Defense. Morning, everyone.
Now, we are going to proceed to select a 6-person jury, and during the selection process, the attorneys and I are going to be asking you some questions. The law requires you to take an oath to answer those questions truthfully, so now what I need from you, please, is I need you to go ahead and stand up. And I need you all to raise your right hand, and then the clerk is going to administer the oath.
Do each of you solemnly swear to truthfully answer all questions asked of you by the court or counsel relating to your qualifications for acting as jurors in this trial? If you agree, answer, I do. I do.
Thank you so much. Go ahead and be seated. The right to a jury trial, of course, means the right to an impartial jury. It's important that all jurors decide the case based on the evidence presented during the trial and on the instructions on the law that I'm going to give you at the end of the trial. When the attorneys and I ask questions, it's to make sure that you're going to be able to put aside any preconceptions that you might have and decide the case based just on the evidence and just on the law. That's why we're asking the questions that we do. After the attorneys and I ask the questions, each side will then have the opportunity to exclude up to 3 jurors, and those are called peremptory challenges. That means that the attorneys don't have to give any reasons for the challenges. The decisions are going to be indicated privately. No one's going to be embarrassed. And at this time, I'd like to begin by asking just some general questions to the entire room. And if you would answer any of these questions, you can just raise your hand, and then I can go ahead and call on you. I'll ask you what your name is. I may ask some follow-up questions. The attorneys will also have an opportunity at that point to ask any additional questions. So the first question I have is, has anyone heard of the case State versus Antonio Waldo before? If you have, go ahead and raise your hand. When you were in the lobby previously, did you hear anybody discussing the case at all? Do you know Mr. Waldo? Yes, ma'am. Number 7. What is your name, please?
My name is Cynthia Davenport, and my son and him were best friends.
And so is that going to, go ahead and be seated, is that going to prejudice you in any way hearing the case today?
I don't believe so.
Okay. And do any of the attorneys have any questions?
I do, Your Honor.
Go ahead.
Number 7, how long have you known the defendant?
I'm trying to think, 6 or 7 years.
Okay, and you've been around him numerous times as your son's best friend, is that correct?
I have a little bit because they were kind of, I'm not gonna go into anything else.
Okay.
Not a lot.
Okay, so in jury selection, what we're trying to do is find a jury that doesn't have any preconceived notions of any of the witnesses or any of the parties here. So
And
that,
I might.
you do?
that.
Okay, so we don't want one party to have an unfair advantage based upon the jurors that are sitting here. So you think that you might have a problem being fair and impartial since you know the defendant as your son's best friend? You know, we'd ask for exclusion of this juror.
Okay. And Mr. Kazmarek, did you have any questions?
No, Your Honor.
Okay. Ma'am, I am going to excuse you because I think it may give you an unfair advantage as far as knowing information other people may not.
All right.
So thank you so much for showing up. Really appreciate it.
You're welcome.
Does anyone else know Mr. Waldo? Do any of you know either of the attorneys on either side? I'm going to read the names of the potential witnesses. If you know any of them, do me a favor and raise your hand. The state is going to call Deputy Courtney Potter, Mike Romo, and Deputy Steve Ross. Do any of you? Yes, sir. Number 11. Your name, sir?
I'm Owen McHatton. I'm named Mike Romo,
And how do you know Mr. Romo?
former coworker.
Okay. And is that going to prejudice you in any way if he's one of the witnesses, ma'am?
Not at all.
Okay. Does anybody have any follow-up questions? Mr. Kazmarek or Mr. Crow?
Yes, juror number 11, you said you were former coworkers. What was the job that you worked for together?
Retail at Walmart Ocean Beach, if this is the same person.
Okay, and how long ago would that have been?
Oh, goodness. 3 years ago?
And about how long, if this is even the same person, how long did you work together?
Oh, about 1.5 years.
Okay. Did you interact socially outside of work?
Not really.
Okay. And how frequently were you guys working together?
Oh, he was a role above me for about 6 months.
Okay. Was he your direct supervisor at any point?
No, just like an assistant.
Okay, and, do you have, an opinion one way or the other about this individual that's, saying Mike Romo?
No, I can be completely neutral.
No further questions, thank you, Your Honor.
Okay. Thank you. So does anyone else know Deputy Ross, Mr. Romo? Okay, let's talk about the defense witness. Defense witness is a Dakota Otten. Does anyone know a Dakota Otten? Okay. Now, as I said earlier, the defendant is accused of criminal trespass in the 2nd degree. I'd like to ask if any of you have had any personal experience with this kind of case before. After we've heard all the evidence, I'm going to give the jury detailed instructions on what the law is. I'm going to give you the exact legal definition of criminal trespass in the 2nd degree. I'll go over how the defendant is presumed innocent, how the state has a burden of proving each element of the charge beyond a reasonable doubt. I'll explain what the role of the attorneys is, what my role is, and what the jury's role is. These instructions are written out for you. I will read them to you. You will have a copy to take back into the jury room with you to refer to when you are doing deliberations. So that it's important that everybody's on the same page when you're back in the jury room. By that, I mean deciding the case based on the instructions on the law, regardless of what you personally think the law should be or what the law is. So I'd like to ask whether there's anyone in the room who can't assure us you're going to follow the instructions that are given to you as to what the law is. Is there anybody in here that's going to have a problem with that? As I said earlier, we expect this case to be done at the end of the day. Would serving on a jury for one day cause any substantial hardship to anyone in the room? Is there anything about the case, and I know you don't know a lot right now, it's just criminal trespass in the second, but is there anything about the case that would make you be prejudiced one way or the other and think, I don't think I can hear that case? Does anybody here have those kinds of feelings at all? Finally, do any of you know why you should not be able to sit on a jury for today? Now, when you checked in, your names were drawn in random order. I'm going to ask the clerk to read the first 12 names on the list, and actually, I think there's only like 11 of you. So, clerk is telling me she doesn't have to do that because we have about 11 or 12 people here. So what we're going to do is each attorney is going to have about 15 minutes to ask you additional questions. And again, remember, it's not because they're being nosy. We're just trying to make sure that we have the best jury set possible. And so we're going to go ahead and we are going to start with the state. Go ahead.
Okay. Ladies and gentlemen, I guess the first thing I would ask is, anyone ever trespassed on your property? Have you ever had someone that at your home, and if you do, just raise your paddle, and as we get into it more, you might jog your memory, but someone that went in your backyard, broke into your home, went into your vehicle. Anyone had their car broken into ever? Juror number 8, juror number 4, juror number 2. Is there anyone that hasn't had their car broken into? All right, so it's about 50-50. All right. What about, as we kind of talk about it, a business that you work at? Have you ever had anyone in your business come in that was excluded or shouldn't have been allowed into your business? Yes, 11 and 12. So juror number 11, what was that?
Just working in retail, customers that have been trespassed or excluded from their property still making their way on and trying to get into the facility.
Yeah.
That's all.
Okay. And as a business, there's certain people that you wanted to exclude, correct? Is that?
Well, if they violate rules and regulations of the building and the business, of course.
Okay. And if you hear facts about this case involving someone trespassing, potentially on property of another, is your role at Walmart, I'm assuming, going to affect your ability to be fair to both sides?
Oh, absolutely not. I was open-minded, of course.
Okay. And does anyone have a problem with the issue that businesses or people that own property can exclude others from coming on their property? Does anyone think you should be able to go wherever you want to go, whenever you want? Okay. And juror number 12, you've raised your paddle, it's kind of like bingo. Tell me what that was about.
Pretty much same thing, sir. I work in retail and we trespass quite a few people for stealing them.
Right.
And they tend to come back time.
Okay.
Even though they've been trespassed.
Okay. And in Washington, there's a law that says if you've trespassed someone or given them notice that they can't come back, and that they do come back, that it's a crime called trespass. So is there anyone that here have a problem with the fact that it's a law that says you can't trespass on someone else's property when they've been told to not come back? Does everyone agree that if the judge says that it's illegal, when you've been trespassed from property or given notice not to come and you come back, that you can be found guilty of a crime? Does everyone agree that law is an okay law and they'd be able to follow the law if the judge gave them that instruction? Anyone disagree? Juror number 1, I haven't talked to you yet. How do you feel about the ability to exclude certain people from property? Do you think that's a good rule or a bad rule? Like from your home, do you think it should be an open door policy that anyone can come in your home whenever they want? Okay. And what about your backyard and your yard? Can people just come and go as they please? Okay. So the difference criminal trespass second is about open lands and property, like a yard or a public area where someone could be excluded from. So trespass can be in a building, but it also can be in like your yard or someone's outdoor area. Would you be able to follow the instruction that says that it's illegal when you've been trespassed to go into someone's land or yard or open area? Does that bother you at all? Like,
Well, if it does say no trespassing, I would follow it.
okay, great. And juror number 2, is that correct? I think, yeah. And are you fine with the fact that it could be a business, not just someone's personal residence, like we've heard before about retail businesses, but businesses have the right to say, you know what, you can't come here. You have broken rules and we don't want you back. And if they do come back, it can be a crime. Are you okay with that law? Okay, is there anyone here that believes in we should be able to go wherever, we're Americans. We got freedoms, and we just get to go wherever we want to go, wherever, whenever we want. Does anyone feel like this planet is just wide open, and I can't be excluded from where I want to go? That's what I'm really getting at. If anyone feels like, you know, I can go, you know, back where it says employees only, I can go back there. Oh, it's at the bank? I can just go at the bank, you know, back there. Oh, you told me not to come back? I'm going to come back anyway. Does anyone feel like our freedom should say we get to go wherever we want, wherever we want? Anyone feel that way? Juror number 3, you're going to hear that as Mr. Waldo sits there today, he's presumed innocent. So he has no duty to do anything. It's upon the state, Ms. Dunlop and I, to present evidence, whether he's guilty beyond a reasonable doubt or not. Do you have a problem with that? That he's presumed innocent, that it's up to the state to prove the case beyond a reasonable doubt? Exactly, and have you been a juror before? Was it a criminal case or a civil case? Okay, and was your jury able to reach a verdict? Anything about that experience as a prior juror that maybe doesn't make you feel like you'd be the best juror on this case? No. Okay. And how many other jurors have sat on a criminal case before? Anybody? Juror number 6. Okay, juror number 8. Same questions to you, jurors 6 and 8. I'll start with 6. Anything about that experience that you didn't enjoy, that you feel like you couldn't be fair and impartial today? No. And juror number 8, what about you? Anything about that experience? Do anyone on the subject, do any of you jurors know each other? And be like, oh, you know, that Crowell prosecutor guy, I can't be in a jury with him. Anyone know each other? Because that sometimes does happen where some of the jurors know each other and they'd have different kinds of influences on each other. Okay, juror number 4. There's one instruction that says that the state proves this case beyond a reasonable doubt, that the jurors have a duty to find the defendant guilty. What do you think about that?
If you prove the case beyond a reasonable doubt, I think it's my responsibility to move that direction.
And does anyone disagree with juror number 4 and feel like, you know what, people make mistakes, you know, defendant seems like a nice young man, we should find him innocent, even though the state found him, proved beyond a reasonable doubt that he was guilty? Does anyone disagree with juror number 4? Okay, juror number 5, I don't think I've talked to you yet. So there's going to be a jury instruction that the court says, and I'm trying not to block you out, that says that circumstantial evidence and direct evidence can be given equal weight, so that not just direct evidence comes into trials, but also circumstantial evidence comes into trial. So, for example, like circumstantial evidence versus direct evidence was, if you see me go over and move this microphone, you observed it as a witness, and that would be direct evidence. If If that microphone was there and I was the only person in the room and you went out and then it's gone and you came back in, circumstantial evidence would be like, I think prosecutor moved that microphone. Because you make a reasonable inference from the circumstances. So in this case, you probably will hear evidence of both direct and circumstantial evidence. So sometimes you'll hear in the media like, oh, it's just a circumstantial case. But the law actually allows you to make reasonable inferences. What do you think about that?
I think that's fine. I don't really know much of the differences about it, except for the example you gave me, so.
Yeah, probably the first time you ever thought about it. Okay, fair enough. Does anyone kind of disagree with juror number 5 and think, oh man, if there's circumstantial evidence and direct evidence, it's only the direct evidence that someone says something or saw it, but not the circumstances of the event. Like, I can't handle circumstantial evidence. Does anyone have an attitude about circumstantial evidence? Or can everyone agree to follow the judge's instructions on the law, which says circumstantial evidence can be as probative as direct evidence? So raise your paddle if you have any problems with that issue. You're going to hear that this case involves Willow Grove Park. Does anyone have any issues that have happened at Willow Grove Park? Has anyone had a conflict there or had problems there where they wouldn't be able to hear kind of the testimony, or it might kind of distract them because of your prior events? Nobody? Okay. All right. And let's see. So what's your juror number?
9.
Juror number 9, I don't think I've talked to you yet. So you're going to hear testimony in this case from a security guard. Have you had any issues with security guards in your life and your work where that would impact your belief to treat them as any other witness?
No.
Has anyone ever had like, oh, I had this security guard and they were wonderful and they saved my life, or they were horrible and I can't stand security guards? Anyone have any issues with security guards where it might not make them the best juror to sit on a case involving a security guard that's going to testify? Juror number 10. Yeah. How about police? Have you had any interactions with police where you felt like they saved your life, saved your family, or on the other side, you had a problem with them and, if they testify as a witness, we're either going to give them too much credibility or not enough? How about anybody else? Has anybody else had anything with police officers where what we're trying to find is jurors that are most fair for this case? So Mr. Kazmarek doesn't want a juror that's going to be like, oh, they're going to be really pro-prosecutor, or we don't want someone that's going to be like, look, we don't believe anything that this person's going to say because of a prior experience. Has anyone had any experiences with police, either very, very favorable or just that they weren't, that would not make you the best juror to sit on this case for both sides? What about prior experience in the criminal justice system? Is there anyone that either has been a victim or a witness in a case, or maybe even a defendant in a case, where they don't feel like they can be fair to the defense and the prosecution? They feel like, had a great prosecutor in some case, and they were awesome, or had a terrible prosecutor and didn't get any information back, and don't like prosecutors, don't like defense lawyers. Anyone that feels like their experience in the criminal justice system gives one side here a little head start. Is there anything else that, as we've talked about, trespass, that you've kind of thought, you know what, I did have someone trespass in my house and burglarize my house or came in my yard? Is anyone, as we've talked about it more, have any prior experience with people coming into their space that they didn't think of before? Is there anything that I mentioned that later you thought, oh, wait, I should have said something, and you can just, yes, sir?
I believe I was 18, maybe 17, at the time, but I went to a party in high school, and that was on, private property, and I didn't realize that. So there was a group of about 20 of us that all had to go to court, and, they went through the whole thing with, I think it was the lowest charge for criminal trespassing that you can get. And we got off with essentially a warning, and community service, small community service. So, but it was deferred.
I understand. Is there anything about that experience where you're like, well, geez, I had to face this criminal trespass issue as a teenager that makes you either feel like the defense is at a disadvantage or the prosecutors are at a disadvantage, or do you think you can put that out of your mind and be fair in this case and make an impartial decision?
I believe I could make an impartial decision. It's 15 years ago. I was a kid in the wrong place at the wrong time. So basically what it came down to.
Great, thank you. I don't have any further questions, Your Honor.
Thank you. Thank you for sharing that as well. Mr. Kaczmarek?
Thank you, Your Honor. Okay. Morning, ladies and gentlemen. So Mr. Crowell asked a lot of questions about trespass and about the idea that you would have somebody come into your backyard, talked about somebody who goes into a marked employees only area, that sort of thing. You all understand that if, actually maybe for number 11, you worked in retail, right? You talked about employee trespass. But it was the case at the Walmart you work for, it's generally open to the public, right? And so if somebody was trespassed, was there a process that the store had to go through to let that person know that they were trespassed?
Yes, security would speak to them and give them all the information, not people on the floor or whatnot. And if they return, it would be security or loss prevention that would continue with the trespass person, not someone else on the floor. It will always be security or
And so there was a process, and I'm assuming there was a store policy or something like that that security even probably had to follow in order to be able to validly trespass somebody from the property, right? And a retail employee, somebody who wasn't authorized to trespass somebody and told them you have to leave, that wouldn't be a valid trespass, right?
Oh, that would be extremely invalid. Paperwork would have to be done, rules, processes.
And I guess, does everyone else sort of understand that the law around trespasses, and the judge will instruct you on this, but it's a little different if we're talking about publicly accessible land versus private property, your house, your backyard, somewhere where you are the sole owner. There's no expectation that a general member of the public is not allowed to be there. Juror number 4, does that make sense? And I guess, we can see show of hands. Has anyone here ever made a mistake? Or I should say, been mistaken about something? Yeah, I can see nods all around, right? We're all human. Maybe let's zero in a little bit more. Say juror number 5. Have you ever had a conversation with somebody and realized after that conversation was over that you and that other person really had a very different understanding of what was said? And, understand maybe later you realize something happens where, the person is perhaps upset with you because what they thought they were saying and what you heard them say were not the same thing. You know, is that, let's look around. Anybody else had a situation like that? Been in that situation before? Yeah, you can see it all around. It's the sort of thing that happens. So you all understand that one of the things the state's going to have to prove today is that Mr. Waldo knew that he wasn't supposed to be where it's alleged that he was. I guess you all understand that, you know, somebody can make a reasonable mistake. If they make a reasonable mistake, that can mean they didn't actually know what.
Objection, beyond that argument.
I'm going to overrule. Go ahead.
Okay. I'll understand that the state's got to prove, you know, if there's some evidence that Mr. Waldo was mistaken, that mistake wasn't reasonable. Basically, we don't hold people criminally liable for honest mistakes, at least not in the case of trespass. Does that make sense to everyone? All right, and that sort of dovetails with what I'd like to talk about next, which is, you know, presumption of innocence. Juror number 6, you were, have been a juror in the past, right? You've been on a criminal jury in the past? So I guess maybe, you know, since you've got a little bit more experience, you know, could you talk about what the presumption of innocence means to you?
I kind of relate that to the law that you are presumed innocent until there's enough evidence to convince you based on your instructions that the person is guilty beyond a reasonable doubt.
Yes, ma'am, and that's an excellent summary. So at what point in a criminal trial can that presumption of innocence end?
My personal response to that would be when you've gone through every detail of the information provided to you.
Okay. And so, just as sort of an academic exercise, juror number 4, you know, if you had to enter a vote right now without any evidence being presented of guilt or innocence, how would you vote?
I don't think I could.
Right, exactly, because the state hasn't proven its case yet. Now, you understand, the judge said this, that the charge is only an allegation at this point. Do you all understand that, you know, basically, Mr. Waldo is not guilty of this crime until the 6 of you who end up serving as this jury vote to convict him, if you vote to convict him. All right, and you talked about this a little bit, ma'am, but does everyone understand that you know, we've got to go in order, right? Both sides can't go at the same time, and the prosecution traditionally gets to go first. Can all of you keep an open mind and not make up your mind until both sides have had a chance to present the evidence to you all during the trial today? Juror number 1? Nodding. All right, in this case, Mr. Waldo is charged with trespass. In part, as I said, the state has the burden of proving that he knowingly entered an area that he was barred from entering. Do you all understand that there's a difference between this type of case, which is a criminal case, and say, a civil case where 2 private parties are suing each other? And understand, and I don't recall, has any juror been on a civil jury in the past? Juror number 4. So what was the burden of proof of that civil?
It was actually called and then it was dismissed. The whole case was dismissed, so I never really got to fulfill the obligation.
Understood. So the burden of proof in a civil suit, which is 2 private parties suing each other, they have a dispute, and that's the preponderance of the evidence. Basically, which of these is, you know, who's got 51% of the evidence on their side? Do you all understand that that's a lower burden than the one that you are being asked to employ today? You know, which is beyond a reasonable doubt. And I don't know if any of you think, juror number 2, have you ever heard of cases where there's something called the standard of proof is preponderance of the, or is clear and convincing evidence? Does that case ring a bell?
To be honest, this is my first time being on jury.
Mhm.
The last time I was called, I was not. I was missed.
Does anybody believe, basically, well, I'll go back, somebody else, does anyone say juror number 12, why is the standard in a trial like this beyond a reasonable doubt, what do you think? Why is it that highest burden?
Don't really understand.
Well, yeah. Okay. Maybe juror number 3. Why do you think that the state's got that high burden of proof in this criminal trial?
Because the law says so. I don't know, because
Juror number 4, do you have any thoughts on why the standard is so high in a criminal trial like this? Excuse me, I'm sorry, juror number 6, I apologize.
I would assume simply because it is a criminal charge and the, punishment could be more severe in a criminal case than in a civil case.
That's exactly the case, ma'am. We're not just talking about monetary damages, we're talking about potentially someone's liberty at stake. So there's that extremely high standard, and the judge is going to instruct you on it. Does anybody have a problem with that? Does any juror think that the standard of proof should be lower or should be different in a criminal case? That it shouldn't be beyond a reasonable doubt, that that's too high? Now, in this case, then, after all of the testimony is there any juror that would hesitate to vote not guilty if they weren't convinced beyond a reasonable doubt that if the state didn't meet its burden? Does anyone feel like they would hesitate or have a hard time voting to acquit? And if you're not firmly convinced, that's one thing, right? These jury deliberations, the jury comes to a decision as a whole, but each juror, does everyone understand that you as a juror are charged with making an individual evaluation of whether the state's proved its case? Is there anyone that thinks, well, I'm not convinced, I think that I want to vote to acquit, but the other juries, other jurors don't feel the same way? Does everyone understand that it's still your right and your duty to vote your own conscience, not what the rest of the group believes? No, that's all right. Does anyone here have a relative or a friend who's in law enforcement? All right, I'm sure number about 50-50. Juror number 10. Who is your? How are you related to a law enforcement officer?
Friends.
Okay.
Only.
Anyone who's got say a close family member, an immediate family member who's a member of law enforcement?
brother-in-law.
Okay. Yeah, and myself, my father's a retired law enforcement officer, and Mr. Crowell asked a little bit about individual interactions with law enforcement, and I think in a wider sense, I agree, most people are generally in favor of law enforcement. I myself, former prosecutor in the Marine Corps. I work
Objection, Your Honor. This is not proper jury selection talking about.
Sustained.
Understood. If a police officer testifies, are you going to believe, is there any juror that's going to believe him or her just because that person's a member of law enforcement? No. Can everyone agree that here in this trial, statements made by law enforcement should be given just as much weight or as little weight as a statement by any other witness? All right, I want to talk a little bit. Have any of you had a friend or a family member, or you yourself have been a victim of a crime? Okay. Juror number 3, is that experience going to influence how you evaluate the evidence in this case?
I would say not.
Okay. Juror number 11, how about you?
I don't know.
All right, and juror number 2?
No.
All right. let's see, hypothetically, the judge is going to instruct you that Mr. Waldo has the right to remain silent. Hypothetically, let's say that if Mr. Waldo does not end up testifying, is everyone going to be able to follow the judge's instruction that can't be held against him? Is there anyone who thinks, that Mr. Waldo should testify? Is there anyone who's going to think that it's suspicious if he doesn't testify? How many of you are parents? Most of us. Juror number 10, do your kids, or excuse me, juror number 10, do your kids ever get into arguments?
All the time.
You ever find yourself in a situation where you got to figure out, who's telling the truth, and you've got two different stories about what happened? And how do you do that?
I ask them, I guess, when, where, why, how, and I try to figure it out in my head with what they tell me.
Okay. And would you expect, if there was any evidence, anything you saw that maybe gave you some idea of what happened, that'd be consistent with, at least one of their stories?
Sometimes.
Would you use that evidence, and whether it lined up with what they were telling you to decide whether they were likely telling the truth or not?
Yes.
And another juror who had children. Juror number 8. What about a situation where your child told you something happened, or there was a fight between your children, and then you didn't see any evidence to support what they were telling you?
Can you repeat that, please?
If, say, your children got into a fight, you have two different stories. You're looking at the evidence, right? You're looking at what's in front of you, and there isn't any evidence to support one of their stories. Is that going to affect
Well,
how you
what
decide
I
to
used
tell the truth?
What I used to tell my kids when we had this type of situation going on, I told them that if I found out that they were lying, they were gonna be in more trouble than just fessing up.
Okay.
And sometimes that worked, and sometimes it didn't.
Understood. Was anyone thinking, on their way here this morning, I might be on a jury and wondering what the person did wrong? Wondering, juror number 3, you find yourself wondering, well, if I'm on a jury today, I wonder what the person did wrong?
I wouldn't say what the person did wrong, it's just what the case would be about.
Exactly, and that's exactly right. At this point, the judge said, all we have is an allegation, there's no evidence until you start to hear the witnesses that anything wrong. Does everybody understand that? Okay. And, Mr. Crowell asked it, I'm going to ask it again, just because I think it is very important. Is there anything that anyone has going on in their life right now that's going to distract you or prevent you from giving this case your full attention today? And one follow-up, juror number 2, I'm sorry. What department does your brother-in-law work for? Sorry.
He's a detective. I don't know.
No, what city or county?
I don't know.
Longview. Have you seen other police officers socially? Have you ever brought friends from work to party or anything
No,
like that?
I'm not the family member they want me around. I was not the role model student, and so he's older. So I was not the child that they wrote around. I was the black sheep. So
Okay, so
I don't socialize.
you don't socialize with your brother-in-law or his law
Not
enforcement
socialize with my
friends?
brother-in-law, but I have no nothing with any of his coworkers. No nothing.
Okay, thank you. Thank you very much. Your Honor, those are all the questions I have.
Thank you. Okay, now that the attorneys and I have had a chance to ask our questions, we're going to go to the final step, and that's a peremptory challenge that I was talking to you about. This is where the attorneys get to use a peremptory challenge for any reason that they want for up to 3 jurors. So what we're going to do at this point is they are going to go ahead and they are going to make their peremptory challenges. So gentlemen, when you're ready, you can go ahead and approach the bench.
We're ready whenever the defense is, but I'll sit down.
Okay,
Are you ready?
you ready?
Yes, sir. We would be alternating, correct, with the prosecutor going first?
That's fine.
And do we hold up a piece of paper, because that's how we did it last time?
Yes.
Okay.
You just have the one.
What was that?
You just had the one?
So far, and now it's their turn.
Okay. Okay, thank you. Brittany, are you writing them down? Okay. Okay. Thank you.
Should we approach?
Yes. Yeah, I know, and then my last round, so that was 11. So we're not gonna have enough to continue. I can hear you. Here, come closer. let's go ahead and let's bring the bailiff up. We're gonna bring the jurors out for a minute. Yes, go off the record.